Akishatoka kwetu anasumbuananga na ingia affairs za huko kwetu. Mtoka Media Max. Lakini akili yake control what is happening there.
Have we taken the quorum?
Yes. The petition that has we called out 522.
Yes.
And the client we represent, each of us, as part of the quorum sheet which we have taken. Impeachment, where is stated in petition 561, so that in our view it would have saved judicial time to consider here the petitions that we have filed after the impeachment. That is cohort 2. 565 was part of the cohort 2. That was the position when we last appeared before this court. However, in 522, by a person we do not know, seeking to be substituted as the petitioner in the place of the petitioner regarding Gachagua'S, on the basis says that the issues raised were matters of public interest, so that he wanted to step into our shoes in 522 and argue our petition. And we considered that that cannot and is cannot and is not in the interest of the client we represent regarding Gachagua'S. Because, for example, there is absolutely nothing to stop that substituted petition from recording consent orders adverse to our client. So to safeguard our client's interest and position, and given that our notice of withdrawal had not been formally accepted by this court, we have filed a notice to withdraw that withdrawal in petition 522 so as to preempt a potentially hostile applicant for us prosecuting that petition to the prejudice of the client we represent. And that is a matter that came before my Lord Justice Rima this morning, bench which is here in the other matters. So we would seek directions regarding the prosecution of our application for withdrawal or withdrawal, and presumably if the applicant for substitution wishes to argue substitution, that can also be had. So we are in your Lordship's hands, your Ladyship's hands, regarding directions in that application in 522. I thank you.
My name is Malenya. I appear for the intended petitioner by the name Frederick Muller. We did file an application dated the 19th of May 2025. It came before your Lordship, Justice Ogola. You did give directions that the matter comes before the three-judge bench on the 5th of June. And when the matter came, it was given today's date. The application for substitution is to be heard, or rather was slated to be heard today, this afternoon. However, I do confirm that I've also been served with another application, or rather I've been served with an application by the first petitioner. That is the application dated 16th of June 2025. I have filed a replying affidavit to this application and served all the parties today morning. My Lord, I don't have a response to my application dated the 19th of May 2025. Despite service to all the parties. However, we are willing to take directions on how we will proceed with that application for substitution.
What prompted the filing of that application? These are the applications which we share with chambers. Yes.
Lord, if I may attempt to be of some assistance that is being created either deliberately or unwittingly in this matter, by referring to the petitions by the numbers by which they were filed originally. My Lord, I believe the prevailing circumstance in the matter before you is that all the petitions have now been consolidated. And the issue of 522, 565, or 5 anything else now does not arise. Second, Larek Senior Counsel has taken the court's time and been on his feet this afternoon, and sought the court's directions as to how a certain application, 29, envisage the manner in which all and any applications will be dealt with. And my Lord, if there are any applications that have been filed or any parties who seek to file applications, with tremendous respect, that is the way this court has directed that those applications will be dealt with. There is no motion before the court for you to review that direction, and there is no appeal from that direction. And we as respondents are guided by that direction, and it is our legitimate expectation that that is the way any application is dealt.
But unless you enforce that order you made, we will just keep doing what I told you earlier on in this litigation, doing the pendulum. Too much motion, but no movement.
Today's proceedings was expected to be quite short because we simply wanted to find out if parties have complied with the directions which we gave last time. But then we are able to see these two applications. I don't know if you want us to make a formal ruling on those applications or whether a verbal direction would suffice. If you expect a verbal direction, then the directions were given, which covered those two rulings squarely. Those directions are there. So what you could be asking is probably to amend those directions if you want to go that way. So we are clear that we gave directions concerning filing of applications and determination of all applications. Should there be a serious need to amend those directions, then you should move us appropriately. Then there's a second application, which we looked at, and despite us having given those directions, the second application. There's an application in 565. There's an application in 565. It's actually a very strange application. It's strange because we don't know whether it's an application which should be heard by us. And it's also an application we'll be very delighted to grant. It's application dated 29th of May by the firm of Tembei, Gichuru, and Company Advocates. I don't know if counsel have been served by this application. Who is the owner of this application?
Justice made a decision. The petitioners I represent alongside the problem with the decision made by the Chief Justice. Under Article 50, that decision of the Chief Justice is reviewable. But since that particular decision was made in this particular file, and the decision can only be made in this particular file, it is the reason why we filed the application. According to the portal, it went before Judge Mugambi, was actioned before her, but I believe she did not deal with it. So we expect that today, because the only prayer that can be handled by this bench is to forward the file to the Chief Justice, that there would be no big deal about it. The matter be forwarded to the Chief Justice to give us directions. We used to have all these kind of matters when there was Chunga and there was Justice Gisheru. So there's no big deal about the application. So we hope that the application, the file with the applications will be forwarded to the Honorable, the Chief Justice, for her reconsideration of those issues.
The Honorable Court will place to forward this application to the Honorable CJ for hearing.
Yes.
So it is the application, not the entire file.
No, it's the application. Yes, whichever way it's done, but the application. But the application is only filed in the file, yes.
Lordships who are on that side.
I will say that if the application is to be considered, then we as the respondents have the legitimate expectation that it will be considered as directed in the directions that you have already made and that the court has referred to. Secondly, my Lord, to carry out an absurdity. In an appeal that we participated in, and in a decision of the Court of Appeal that I'm sure your lordships and ladyship are only too familiar with, the power that my good and learned friend Mr. Kibe seeks to have the Chief Justice review is characterized as an administrative power. The Chief Justice, and I believe this is paragraph 139 of that decision, the Court of Appeal is clear that the Chief Justice is not a judge of this court. And the absurdity is this, my lords. You are being asked by counsel to refer an application made in a file for judicial determination by a judge who is not a judge of this court. If the Chief Justice is conducting an administrative or was discharging an administrative power when she considered to empanel your lordships under Article 165(4) of the Constitution, we all know how you challenge an administrative decision that you are unhappy with. And it is not to come to this court, file an application, and ask this court to refer the file to the Chief Justice. And thirdly, my lords, it is apparent that the petitioners are not interested in proceeding with this petition. Because what is then urged in the part of the application that your lordship did not read is another application for recusal. That issue has been ventilated before this court, if I may say, in a rather bad-natured manner. This court pronounced itself on that issue of recusal, and the Court of Appeal also pronounced itself on the issue of recusal. My lords, my lady, our request is that you remain firm about the directions you issued on the 29th and proceed with this matter as you had directed. As my good and learned friend, Dr. Mudomi has stated, if you don't assert yourself in this matter will not proceed. These petitioners are not interested in proceeding, but you have a duty to sit as judges who have taken an oath under the Constitution, and we urge you to do as much.
Progression of this matter is not affected, because if they claim that now we can't proceed because that application is before the Chief Justice, then it will be obvious to anyone who has a brain that the real motive of the application is to derail the expeditious hearing and determination. Then, my lord, perhaps it's my young years, but my understanding of the architecture for constitutional litigation in this country is that the only time this court can refer a matter to the Chief Justice is under Article 165(4), where this court has certified that there is a matter of significant legal question that needs to be referred for, and when the court certifies that matter, the Chief Justice's sole duty is to constitute a bench, because the Chief Justice does not determine anything else. So I would be interested to know which is the question raised in this application within Article 165(4) that raises a substantial question of law, because that is the only window under our constitutional architecture. This court has to refer any matter to the Chief Justice. And if I am correct in that submission, my lady and my lords, it would mean even the prayer you are very happy to grant, you actually have no jurisdiction to grant it. Thank you, my lord.
Yes, my lord. If you look at the prayers, prayer 2 says, you forward this file to this application to the Chief Justice for hearing and determination. My colleague Mudomi has correctly submitted that you have no jurisdiction to forward an application to the Chief Justice for determination. You have no such jurisdiction at all. Secondly, I was asking myself, what do they want the Chief Justice to do? And then that question is answered in prayer 3. They want the Chief Justice to review and set aside a decision to appoint this bench. And then that is where the strangeness then really is conspicuous. Because they have rightly admitted that the power of the Chief Justice to set up a bench, to constitute a bench, is an administrative power. If they are not happy with this power, the way it was exercised, the best way is for them to file substantive judicial proceedings to challenge the appointment which was made by the Chief Justice. They cannot expect this bench to forward this application as drafted to the Chief Justice to issue an order, which appears, if you look at it in the scheme of things, 829 of 2024, where the Court of Appeal expressly, clearly, and unequivocally determined the question of the powers of the Chief Justice to appoint this bench, the power of the Chief Justice to appoint a bench, to determine whether that power is an administrative or judicial power, fulsomely. And then the Court of Appeal left that question, having declared the initial appointment to be unconstitutional, the Court of Appeal left that question to be determined by the Chief Justice. So there's no way you can determine this application. You don't have jurisdiction. The best way for them is to commence a separate judicial process, and we'll be requesting that you issue a ruling that you have no jurisdiction to forward this file to the Chief Justice. They can appeal that decision if they want, or they can file a separate judicial proceedings if they have a grievance on what the Chief Justice did in this matter.
My name is Mukele. My Lord, I associate myself fully with the submissions by my colleagues, my Lord. My Lord, I have had a look at the application, my Lord, and the concern of my client is specifically with regard to prayer 2 of the application. The order sought, my Lord, seeks for the Chief Justice that the file be placed before the Chief Justice for purposes of hearing and determination. My Lord, the application be placed before the Chief Justice for the Chief Justice to hear and determine, my Lord. My Lord, my understanding of Article 165 sub-Article 4 is that the Chief Justice does not then hear and determine the parties. My Lord, the Chief Justice only but constitutes the bench for purposes of hearing and determining the matter which has been referred to her. That is of specific concern, my Lord, to my client. My Lord, it is also our view that the issues that we are submitting on at this moment can be determined summarily. My Lord, we do not feel, it is our view that these issues need not go back for further consideration. They can be determined summarily as we appear before the Lordships today. My Lord, that is, those are the two comments we wish to make on that matter. Thank you, Madam.
I've worked with many times on one side and strikes me as a very good lawyer. Don't know what is happening today. My Lords, the issue, anybody who has read this application would get to know is a simple question. The petitioner simply disagrees with the decision of the Chief Justice. The petitioners simply are saying all decisions made in Kenya by the President, by a policeman, by the Chief Justice can be appealed, can be reviewed. That matter is not for this court. That matter is for the Chief Justice to decide. If she is convinced this is an application each of them are entitled to respond to. So when it is responded to and it is placed before the Chief Justice, the only person who can hear it, under Article 165 of the Constitution, will be able to make a decision one way or the other. So there is no need to break very many bones over this particular issue, unless somebody wants to create an absurdity about it that is actually not there. But it is possible for lawyers to create absurdities where none exist. The application by its nature is jurisdictional. Because for any bench to sit under the constitutions of Kenya, it sits pursuant to a decision made by the Honorable the Chief Justice. And therefore, if there is a contest, which was one of them, it was contested. That's why we are before the Court of Appeal. If there remains any contest, that contest must also be dealt with. There is no power in Kenya, at least as long as Article 150 and Article 50 and 25 of the Constitution exist, for any applications to be thrown out. An application must have a decision that we have considered this is our decision. The persons to consider is a person whom the law says is to consider the issue before them. Therefore, there is a jurisdictional issue that none of us can run away from. Second issue is now where you are being told, apply the ruling, the directions given on 29 to this application. One, this application was not before you on the 29th when those directions were given. And I am convinced, knowing the three of you, that had you seen a jurisdictional applications before you, it is absolutely unlikely that you would have directed that the petitions be heard together with what is a preliminary objections. I am absolutely sure that would never have happened. So there is nothing in those directions that would be a bar to these particular applications being heard by the judicial officer designated by the Constitution of Kenya. Now, on the issue of is it administrative, is it judicial, we are breaking bones. Whatever power is conferred under Article 165 of the Constitution is a legal power. And all decisions made under the law are subject to adjudication if any party is aggrieved by it. So that in itself, I see no absurdity where it would be unless we are stretching logic. Now, the petitioners are not interested in this petition. I wish they were right. I wonder why anybody would file this petition and spend the many hours we have spent when we are not interested. I don't think I need to go very much to that. Dr. Muthomi, my other friend, the applicant should only proceed in the application without, and then the other case can proceed. I think that makes fun of Mukisa Biscuits, the case of Lilianes. All those decisions were very clear on one issue. Once an application that appears to be jurisdictional in nature is raised, that must be dealt with as a first instance issue. But if he's capable, after hearing this application, to convince this court that his position is correct, I would be glad to hear his submissions and response with regard to that issue. That's not a big issue. So there is a jurisdictional issue. It is not capable of being split. It's the same way. When there is a file and the court has said this application, the consideration of the issue be taken to the Chief Justice, I don't know whether it has always been taken, and we always have files, even in our own offices, that an application goes to the Chief Justice with a file. So that is my presumption. A file is just a physical document or an electronic document that houses an application. So again, the issue that you can split the two, I do not know how it can be split. Because there is a petition before you by these petitioners who are saying, and together with other petitioners, we have not seen the responses. I've seen a few who are saying we have a problem also with that one, and they will be supporting this application. The matter must be decided. My learned colleague, Mr. Wanyama, the court has no jurisdictions to forward this case to the CJ. My Lord, I do not know. The High Court under 165 has original civil and criminal jurisdictions and a lot of constitutional powers. In fact, this power, unless Mr. Wanyama was not involved in this matter at that particular time, we actually had the situations whereby the Kirinyaga files were brought physically from Kirinyaga and without any application. So it cannot be right that the High Court cannot call any file to either to be brought here or to be taken elsewhere. But if this court were to say And that is what we were trying to avoid. That we would need to write to the Chief Justice to tell the Chief Justice, ask for the file. Again, we would still be able to do that. But the good conduct of all cases, even where judges, and there have been very many instances, where matters have been decided, the judge says the Chief Justice should probably look into this. So this is done every day. So let us not try to create an artificial situation that does not exist. Then we are being told that they should file a substantive judicial proceedings. Unfortunately, each of us here has been instructed by different clients. If he could have filed something different, that is his opinion. My clients, I acted on the instructions by filing this application. It can be allowed, it can be dismissed. That is the fate of all applications. But it can only be allowed or otherwise through a reasoned ruling that by the right judicial officer. So there is nothing much about the procedure that should have been adopted. If you adopt the wrong procedure, it is dismissed, and we've got no big problem with that. Then there is the issue that we are undermining the Court of Appeal decision or this court's decision. We have got no reasons to do that. The Court of Appeal asserted the point we had made before this court, that only the Chief Justice could carry out certain decisions. And of course, if that decisions are made, we submit, they can be reviewed under the Constitution of Kenya. She will decide. If she says that her powers are absolute after hearing our applications, we've got no problem. It will only mean there will be an appeal to the Court of Appeal. So there is no big deal. And Mr. Mukele, that the file be placed before that the issue that can be determined summarily. Well, Kenya may be a dictatorship in other ways, but the judiciary is not a dictatorship. There is no basis upon which the judiciary can summarily dismiss applications as urged by Mr. Mukele. So the long and short of it, my Lord, is that, and as the presiding judge had indicated, the only issue we are interested in before this court is to say, let the Chief Justice consider this application. That is all. If they do not have to argue it today, we shall argue it on a good day. And I am sure the day we argue it on a good day, we shall present extremely good arguments. My Lord, we are most obliged.
In 565 consolidated. So we did not know if to respond now or wait until that file is called. But some of these issues are cross-cutting. So, yes. For one, we support this application, but seek time to respond. So there's no way it can be dealt with summarily. But on our parts, in regard to the directions that were issued on 29th by this bench, there is an issue that is cropping up. My colleague, Mr. Nyamodi, said that the directions are that all and any pending applications be dealt with together with the petition, but that is incorrect, because the directions are all pending applications. And that creates a problem, because it is unclear which applications are pending and which applications have been dealt with. So I stand to seek, once again, clarification in regard to the following applications. One is our application dated 9th October 2024, filed in Gachagua'S petition number E014 of 2024, where the Honorable Justice Mwongo certified the matter as urgent to be placed before the Chief Justice for appointment of a bench, and directing that the matter be mentioned before a bench constituted by the Chief Justice. The second application is the one dated 18th October 2024 in Milimani petition number 565 of 2024, in Gachagua'S petition number 15 of 2024, where again conservatory orders were issued and the matter ordered to be placed before the Chief Justice for appointment of a bench, directions that the matter be had before the appointed bench. My Lord and my Lady, subsequent to the Court of Appeal ruling,
directions, because we have not had any application. These are directions. We have heard and considered the submissions by council in both petitions E522 and E565 of 2024. We refer to our directions issued on 29th of May 2025, particularly direction number 5 on pending applications. At the time of issuing the directions, the following applications were not on record. That is application dated 19th of May 2025 for substitution, the application which seeks to withdraw notice of withdrawal, and then the application dated 16th of June 2025 for referral to the CJ. These applications may appear simple on the face of it, but they raise substantive legal issues this court should consider and render itself on. It is on that basis that we hereby give the following directions. 1, the respondents to those applications are at liberty to file their respective responses within 7 days from today. 2, upon service, the applicants are at liberty to file and serve supplementary responses, if need be, together with submissions within 7 days of service. The respondents to the said applications shall file and serve their respective written submissions. The respondents to the 3 applications shall file and serve their respective written submissions within 7 days of service. Time is of the essence. Any filings outside of this time frame shall stand expunged. We'll make a ruling on those applications on 31st July 2025. There will be no highlighting of submissions. We will receive your responses and render a ruling on 31st of July 2025. Before we conclude these directions, we have taken note of the submissions by Mr. Muge in respect of the Gachagua'S petitions. Given the directions we issued on 29th of May, and with a view to have comprehensive directions on the way forward, this court shall render further directions on these matters and on case management in the ruling to be delivered on 31st of July 2025. Those are the directions of this court on those matters. Thank you.
Application dated 29th of May, the same direction applies to that application.